SJC-11701, Commonwealth v. Christopher G. Magdalenski.
Good morning.
May it please the court. My name is Jessica LeClaire. I represent Christopher Magdalenski. When defense counsel is questioning William Graham, trial judge tells her, quote, "The issue in this case is not how far this gentleman went," end quote. Well, in fact, that was the issue in this case for the defense, because it was Graham's conduct that gave rise to a host of potential consequences to him, potential civil, professional, possibly criminal consequences. The only way for him to avoid exposure to those potential consequences would be if his conduct had been justified. And his conduct was only justified if Mr. Magdalenski had assaulted his sister. These are the connections that the defense counsel was not allowed to make for the jury. The connection between Graham's conduct and his personal stake in the outcome of this case. Now, the defense was allowed to contest or cross-examine these witnesses relative to their perception of this event, their memory of this event. She was not allowed to question those witnesses' veracity. What the judge referred to as the assault and battery event, she was not allowed to contest that there had been an assault and battery event. Now, the only undisputed assault and battery here was the assault and battery that Mr. Graham committed against Mr. Magdalenski. And that situation, his conduct, supported an inference of bias inherently in this context. Now, I'd like to discuss a case that actually stands for that proposition, which is not referenced in my brief. I've brought it to my sister's attention, and it's Commonwealth v. Oliveira, 74 Massap Court 49, 2009. And the question in that case on appeal was whether a particular witness should have been allowed to testify that they had waived their Fifth Amendment privilege. So it's not the precise issue here, but the facts were very similar. And in that case, the Commonwealth alleged that the victim had been assaulted by her ex-husband at a custodial exchange of their child. The victim's friend intervened, punching the defendant in the face, holding him by the neck, pushing him against a wall. And then the victim called the police. And again, the question was whether that witness, at trial, that witness was appointed counsel because it was recognized that that witness had a Fifth Amendment privilege not to incriminate himself, and that by testifying about what he had done to the defendant, he exposed himself to criminal consequences. And so that's the very situation here. By doing what Graham had done, he exposed himself to criminal consequences. And what the majority said in that case is that that witness did inherently have a bias against the defendant because his interests in the case became adverse to that defendant. He was no longer an impartial witness. And again, that was the connection here that the defense counsel was not allowed to make for the jury. Now, that opinion is also important because in a concurrence, Justice Link implied—
I take it there was cross-examination of this, is it Graham?
Mm-hmm. Yes, sir.
There was cross-examination, and the cross-examination obviously went into what, in fact, he did and whether he had, in fact, initiated the assault.
She cross-examines him. Did you tell this, your son-in-law you went too far? Did you punch the defendant in the chest? And he denies that. So
Okay.
There is cross-examination relative to his conduct in the immediate aftermath of the assault. But she doesn't get to question him as to whether or not he had a motive to accuse the defendant because he was concerned about his conduct and the consequences he faced because of that conduct. And concerning this Commonwealth v. Oliveira decision—
So pragmatically, play out for me the cross-examination that would have been done but for these rulings.
she starts to ask him, were you aware that the defendant filed a complaint against you? Were you concerned about the complaint? Were you concerned about your career? Did you call up the son-in-law? Did you speak to the son-in-law about this case? Did you tell him, get your father-in-law to withdraw that complaint? Did you tell them that you were going to call the Department of Children and Families and report them if they didn't accomplish that? Those types of questions, which would have given the jury a reason to ask themselves, did these witnesses have a motive to misrepresent what happened? And the same questions could have been asked of Bethany.
So he wasn't asked, Mr. Graham, if you had initiated the assault here, or Mr. Graham, might you be facing disciplinary charges in your job for having assaulted my client?
That's right. He was never asked that question.
Was he not permitted to ask whether he might face discipline as a result of the assault?
When she started to bring up the complaint...
Put the complaint aside. I'm saying the substance of it, which is that you have a motive to do this because you might be disciplined if you used force when it was unjustified. Was that area probed, or...?
No, it was not, because as defense counsel started to get into her questioning, the judge very clearly cut that off and said, this particular area is, we're not going there.
Well, it's one thing to say you can't question him about a complaint that's been withdrawn. It's another to say you can't question him about what consequences might come of his actions if, in fact, he didn't say that the defendant initiated it.
Well, I think that you see a pattern here as the case moves forward. Defense counsel gives the judge her theory that he did face potential consequences, and the judge prevents her from bringing that up in opening argument. She starts to question Bethany, and he shuts her down. So I think that defense counsel was operating under the belief that that was part and parcel of her question about the complaint, and that the judge had cut that off and said, no, we're not going there. And you see later, when she tries to question the defendant about this, that's cut off as well. So it's part of one theory that she was trying to pursue that kept getting shut down. The concurrence that I was discussing that Justice Lenk made in the Oliveira case, that was important because in that opinion she implies that the jury isn't going to understand that particular witness in that situation, their inherent bias, and that they might be exposed to consequences because of their conduct, until the witness's credibility has been attacked. And that's what wasn't allowed to be done here. Again, the jury the defense counsel was never allowed to make that connection for the jury. And the jury was likely to see this exactly the way the judge did, which is, what did he do and what happened after the assault and battery event, the alleged assault and battery event, wasn't necessarily relevant to his veracity, unless they knew that Graham faced potential consequences by accusing the defendant. Now, this shutting down of the bias evidence impacted the credibility of every witness here, because the jury was likely to assess the credibility of each witness without this knowledge that these witnesses might have had a motive to lie. So, for example, we have Allison, who the Commonwealth refers to as an impartial witness. Well, in fact, we know from the transcript that she was very upset during her testimony. There's a suggestion that she's crying, and the prosecutor in closing mentions that she was crying, and she agrees that she doesn't want to be there testifying against Mr. Magdalenski. Now, the question is, was she upset because she was telling the truth about what she had seen, or was she upset because she felt she needed to side with her mother? That's a question the jury never had to ask themselves as they were weighing her credibility in person. The defendant's testimony that he was the victim, that was unfairly discredited by the prosecutor. The prosecutor is allowed to get into evidence that Mr. William Graham was never charged with a crime. Well, perhaps one of the reasons he was never charged with a crime is because he coerce the defendant through certain means into withdrawing his complaint. So the jury hears testimony from the defendant that he's the victim. They don't hear testimony about why he never filed charges. So that was unfair to the defendant. And now the Commonwealth tries to distinguish this case by arguing that because there were no pending complaints, Graham had no reason to be concerned. Shall I finish?
You can finish your sentence or your thought.
But he was concerned at the time of the incident, and that gave a motive to tell the same story later on. So for these reasons, I would ask that you reverse Mr. Magdalenski's conviction.
Great.
Thank you.
Thank you.
Good afternoon, Chief Justice Gantz, members of the court. May it please the court, Cynthia Von Flatern, Assistant District Attorney for the Northwestern District for the Commonwealth. The Commonwealth would submit in this case and ask this court to conclude, as the appeals court did, that there was no improper preclusion of the defendant's ability to bring out bias on the part of the victim and the witness in this case. It's clear law that a judge cannot preclude a defendant from bringing out all bias of a witness, that is a defendant's right, a constitutional right. But in this case, I would submit that the judge did allow evidence of bias, and on numerous occasions. Did he allow in the defendant to go off on tangents in this case and to elicit evidence that was cumulative? No, but he did allow evidence of bias so that the defendant received a fair trial.
What evidence of bias did the judge allow?
With respect to Mr. Graham.
Right.
Prior to trial, there was a motion in limine from the Commonwealth to preclude the any testimony with respect to Mr. Graham's response or conduct on the defendant, that he put him in a arm hold or that he assaulted him or anything. That was a motion in limine filed by the Commonwealth. That motion was denied. And so this would be a far different case if we didn't have all of that testimony about Mr. Graham's reaction to the defendant's conduct. All of that evidence came out. It came out in cross-examination of Bethany, in cross-examination of Mr. Graham, and with the defendant's testimony, the defendant's testimony was that we had an argument. She was yelling at me. I tried to go in the back door. She grabbed my arm, and all of a sudden my CDs went flying. I never put a hand on her. She fell to the ground, and Mr. Graham came running and assaulted me. And here are pictures to show, assaulted me, who had a heart attack in February, and here's a photo to show that, and here are my broken glasses. So all of that testimony came out.
That's not impeachment of Graham. That's just a contrary story, right? That's the defendant putting in evidence about what happened.
It's the defendant's and...
But it doesn't show Graham's bias or his sister's bias.
Well, it shows, it allows an inference of bias, which the defendant had a right to argue.
How is that?
Yeah, I'm sorry, go ahead.
As the judge a judge identified when they were talking about this case, it allows, and the defense put words to it that the theory was that Mr. Graham went too far, and so then there had to be this fabrication of testimony about what the defendant did. But that really overlooks the fact that Bethany called police. Bethany made a statement that evening as to what happened, and the defendant was arrested.
So why can't he show that they're lying, or they have a reason to lie?
Well, he did by showing by testimony as to
No testimony.
There was testimony from the defendant that of what Mr. Graham. There's testimony that he didn't touch Bethany, and Mr. Graham in fact assaulted him.
I
That was
understand
the testimony.
But he wasn't allowed to cross-examine the other witnesses or even get into anything having to do with their reason to lie.
Well, he was. The reason to lie. So. There was a question about there was a question to Mr. Graham. Did you tell the defendant's son-in-law that the defendant was lucky that you stopped when you did? Yes. He was allowed to have that evidence introduced. In terms of testimony that the defendant was going to bring a cross-complaint or did bring a cross-complaint, I don't know that that's very probative in the sense that a lot of people bring cross-complaints and this was conduct that it would have occurred after the original assault. And I don't think that is particularly probative. When you have evidence of the underlying, you have evidence of what the conduct was. There's full testimony about what Mr. Graham's conduct was, and there's an inference that the defendant was allowed to argue that, and we can see that. The judge could see that, defense counsel could see that, and the defendant could argue that to the jury. So without going in this whole tangent about, then there was this motion in limine on the part of the Commonwealth to preclude the DCF worker to testify about a 51A complaint that was filed. Well, that was not developed at trial. There was discussion about it, but there was no complaint that was brought forth, and there were good reasons. I would submit that was not very, very probative about anything, and the judge, in his discretion, could exclude it when it really went to. There were good reasons to let DCF know that the defendant might be going to stay with his family where there were young children, because the theme from the Commonwealth's witnesses was where they had asked the defendant to leave the home because they were concerned about his drug use, and that was what. And Bethany testified that she told police that she had concerns. She was not allowed to. The defense counsel was not allowed to cross-examine Bethany further to say, "Oh, didn't you tell police that the defendant and his girlfriend were going to go to the daughter's house and there were little children there, or they were going to do drugs in front of the children?" The judge didn't allow that question, but I would submit it's not very probative. It's very tangential, and it's really pretty harmful to the defendant. I would just submit that in this case, I think that the judge used his discretion appropriately, that the burden is on the defendant to show an abuse of discretion, and that while if you look at the transcript, pieces of the transcript together, you might conclude that the judge was not allowing the defendant to develop the testimony and argue from the inferences. But I think when you read the entire transcript, you'll find that there was appropriate discretion used, and that the facts of the case did come out. The defendant was allowed to get in evidence of Mr. Graham's response to what happened, and could argue the witness's bias and the victim's bias. If there are no further questions, the Commonwealth would submit on its brief.
Thank you.
Thank you.